Hey, you are on Real Estate 101 with Olena Sobkovych, and we are continuing our series of programs for newcomers, for those who want to buy first time the property in Canada or in Alberta. We provided lots of information during last 3 months. We met with different people, and now it's the final stage. Our guest today is the lawyer from Danube Law, Andrej Simecek, and he will tell you exactly what he is doing to do the paperwork for your property and what is the process. Hi, Andrej.
Hello, Olena. Thank you for having me.
Thank you so much for coming. We know that the lawyer is the most important and final stage in the process of purchase. Please tell us why it's so important and what is your job? What are your responsibilities?
So, as you mentioned, the lawyer does come at the end of the process, so to say, to tie it up. So that now, at this point, you have secured your mortgage, so you've been approved and everything is ready, bank has provided commitment, and you have removed conditions
We signed the waiver.
on the purchase. Now it's a binding contract. So what does a lawyer do? Essentially, long story short, is they help the client fulfill their contractual obligations. So that, well, what is the biggest contractual obligation on the side of the buyer is to be able to pay the seller. To that extent, the bank that is giving you your mortgage sends their instructions, they're literally called mortgage instructions, directly to the lawyer, who then prepares the documents, the mortgage documents, following those instructions. Sometimes banks have additional requirements, but generally just set up the paperwork. And in this sense, the lawyer is not only looking after the client, because the client, of course, wants a clear title at the end, but also looks after the bank. So a lot of people oftentimes are not aware that the lawyer is retained by both, by the buyer and by their bank. Because to a certain extent, their interests overlap. The bank wants to be sure that they are properly registered on the title. And to that extent, it overlaps with the client because they want a clear title with only their mortgage, let's say.
Unfortunately, it cannot be so, right? Both of them have to be on the title.
Yes, and properly registered and so on and so forth. And yes, and also speaking of the interest, for example, when it comes to property taxes, the lawyer has to check and make sure that they are up to date. If they are not up to date, it happens occasionally that the seller forgot, for example, to make a payment, then you have to make sure that the other side, the seller side, pays those from the sale. Usually they take a certain amount from the sale, paid taxes, or things like that.
It's very good, and it's very worth to mention, I would say, that when the purchaser just comes to the lawyer, they are not touching the money. Technically, you are the person who is dealing with the money from the very beginning to the end. So the bank sends the money to you and you are sending the money to the seller, right?
Yes.
And you are paying off everything that has to be paid, and you are doing the letter of adjustment and show everything to the buyer where the money go. Exactly.
So that is a very large portion of the process for the lawyer, is to make sure that, well, essentially the money goes where it's supposed to, so that the client brings in the balance of the down payment to the meeting.
Right.
And on the day of, on the possession date, in the morning, the bank sends the mortgage. Now, those two combined go over to the seller's lawyer, who then, again, fulfills their obligations, i.e. biggest one, pay out the existing mortgage. But that's something maybe we can touch on in sale, but that's what they do for themselves,
Lots of people are very frustrated right now when they don't get the title when they leave your office. Why it happens so?
So, when it comes to registration process, technically, so you're registering two documents on regular purchase, which is the transfer of land that comes from the seller's side, from the seller's lawyer, and the mortgage. Those are submitted for registration on the possession date. That's
Right.
when you exchange money for the right to go and submit those for registration. And I feel the frustration because the land titles office, before Corona, the standard was 2 weeks, was the processing time.
Right.
Then it jumped to 4 months. Now as we stand in August 2024, it's about 5-6 weeks. So yes, but the title does come sometime after. But that's also I tell clients oftentimes that my work is not done on the possession date.
Right.
And the lawyer continues to be engaged up until the moment where they can give you the land title certificate with your name, your mortgage, and if the seller had a mortgage, that one gone. So.
In which way they receive the title? Is it goes by email or via mail?
So usually I would send a PDF because also that's maybe also a misunderstanding sometimes that there is no such thing as original of the land title certificate.
Our people, they do want to have a paper.
And that's
they do
understandable,
want
right?
to have a proof.
So the fact is that it is the land titles office that holds the originals. So that, like, as I mentioned, the transfer of land and the mortgage, those originals are submitted at the land titles office. They keep them, and then they reproduce the certificate now, and then in the sense they guarantee what's on there. So to that extent, yes, but there is no.
There is no, and I know that if needed and the title is ready, I can technically pull it out
Yes, because it's
from the
public.
system.
It's
Yes,
public information, so anybody can. Yeah.
absolutely, absolutely. Okay, you called the buyer that you received the paperwork from the bank and from the realtor. What information do you need from the buyer when they come to the appointment with you? What they have to be ready for?
So generally, there's identification. So 2 pieces of ID. But the big one usually is insurance.
Okay.
And I would say that's the biggest one that I would need from the client is to arrange fire insurance. Now, banks are very specific, so sometimes you have a little bit of a back and forth. You have to unfortunately correct this, correct that, but I would say that. And
It
then,
has to be done a little bit in advance, right?
Yes,
Okay.
it has to. And then the bank drop with the balance of the down payment, and the rest takes care of itself.
Wonderful. And how about the sellers? If I decide to sell a property and technically I signed a contract with the realtor and I sold the property,
Yes.
what are you doing in this case?
So in this case, the one half of the process is the same. You have to receive conveyancing, so you have to purchase notice, commission breakdown, whatnot. Obviously, you don't have to wait for mortgage, but mortgage is still very important to you. But in the other way around, because what you do as a seller's lawyer, and this is the first thing we do anyway, is if the seller has a mortgage, then we ask for a payout statement from the bank, but let's say a statement, just your mortgage statement. It can be 2 years old, nobody cares. What's important is the identification of the loan. Okay. You then, as the lawyer, reach out to that given bank and you request a payout statement.
Okay.
And let's say closing is August 30th, so you say, okay, on the 30th of August, this property is being sold. The bank then sends you a payout statement, and it calculates principal, interest, repayment penalties. So they calculate it for you down to the day. And usually I would say that's the biggest thing to do. And oftentimes, okay, you have to get RPR, let's say, real property.
It's very important thing.
But yes, so you provide how should I say this? As a seller's lawyer, you provide a binding promise, it's called an undertaking, to pay out the existing mortgage from the sale proceeds that your client gets.
Okay.
So that the other side knows they're sending you money. Right? The buyer, as we mentioned, down payment plus mortgage go over to the seller. Now, your seller, you receive the money. Your number one priority is always to pay out your client's existing mortgage.
Right. So you cannot just transfer all the money to the seller. First, you have responsibilities to the bank,
Because
right?
the lawyer takes it, so to say, on themselves, because now the lawyer is personally responsible because they provided the undertaking to pay it out. So should they not, let's say, then they're facing disciplinary hearings and,
Wow.
and losing their license. But yes, so you take it on yourselves, and similarly with other promises, so to say, or if something has to be fixed, let's say there's damage that occurred between the agreement and the actual possession date, you can undertake to, let's say, hold certain amount of money
Right.
until your client fixes
What
it,
happened, right?
and then use that money to pay the contract, let's say. But yes, but that doesn't happen too often. But
It's very important to mention as well that when you are purchasing a property, you are not getting any debts of the seller, right? And you are taking the responsibility of that as well. So you are doing taxes, condo fees.
yes, absolutely. So speaking of condo fees,
Right.
the seller is responsible for obtaining an estoppel certificate, which essentially it's a certificate from the condominium management company that there's no outstanding condo fees, there's no special assessment levied,
Right.
and then there's no the condo corporation is not being sued, to the best of the knowledge. But so when you order the estoppel certificate from the management company and the seller happens to owe, or they happen to have arrears, the management company will simply not produce the estoppel certificate until, again, you
pay
undertake
it off.
to pay it off. So oftentimes you just say, okay, well, just wait for the closing and we'll pay it out then, because how
I will have the money by that time,
So
right?
yes, so once it's paid off, they produce an estoppel certificate saying yes, it's clear. So
Yeah, it's because lots of people are worried that they are buying a property and it can be any debts for that, like utilities, condo fees, taxes. It's very important to know that they are technically getting clear title, in this case, like with no debts, right? And this is the lawyer who checks everything and does everything.
yes,
Okay, when we are planning to sell the property or to buy the property, it's obviously some problems which can just come up. How can we prevent it? What we have to do? What would be your advice?
if you're selling a house, I would say the biggest thing would be to get a real property report well in advance, so that you avoid any not delay so much, but any issues.
Yeah, usually it takes 2 to 3 weeks just to do the RPR with compliance, right?
Yes. If you're selling a condo, then make sure for example, if there's a special assessment that has been agreed on by the board, because the rule is, if it's been voted on before the closing date, then it is your responsibility as the seller. If it's been voted after possession date, it's buyer's problem. But so, for example, to account for it, so that you account for the fact that you will have to pay out the special assessment.
Right. But according to the contract, actually, it has to be paid off by the seller, right?
If it was passed before the possession date, but it's
Right.
detail. So, because for example, it happens that we are contemplating a special assessment.
Okay, we're just talking about it.
And the
Right?
board is just talking about it. That doesn't then, as long as it's not passed, then it remains with the buyer. But yeah.
Okay, if we have, for example, 2 owners, and one of the owners is out of country at the moment, or simply in the next city somewhere here, is it possible to sign the paperwork via Zoom?
Yes. So this is one of the biggest changes that Corona brought, because it was not allowed before. So let's say your client is in Ontario, they would have to go see a notary in Ontario and then send the documents back. With Corona, what happened is that you are allowed to sign with the client remotely by video conference, whereby you send them, the lawyer sends them the documents, they print out the documents on their end, then you meet on Zoom,
Right.
The client signs, so to say, in front of you, and then they courier the documents back. But it's still not digital signatures such as DocuSign, for example.
Right.
Because it's remote doesn't mean it's digital signatures. There still have to be physical signatures because land titles office will not accept digital signatures.
Interesting, but bank usually they do accept this video conference, right?
Yes, I would say most do, and also what most don't is if you're outside of Canada.
Oh.
Which is interesting.
But who can check that?
Well, they see on the mortgage where we were signed, so they'll know. But plus, I am a lawyer also for the bank, so
right.
I know.
We don't play those games, right?
Yes, no.
Okay, so everything is doable. The most important thing, just to call the lawyer, to ask him, and to do everything step by step properly,
yes.
and he will not get into any trouble.
No.
Good. Can I buy a house over here in Canada, in Alberta, without a lawyer? Is it possible?
Yes. Now, if you're getting a mortgage,
Okay.
no bank will simply let you do it without a lawyer. But assume for a second that you're paying cash.
It would be great.
You have a bag of cash and you say, okay, I'm going to buy a property. There is a process now, but the seller provides the buyer with a transfer of land. The buyer doesn't pay them yet. The buyer takes the transfer of land to the land titles office and waits for registration. Right?
Which can
and
take
once the registration goes through, that's when you pay them. Because imagine you give me all your money and I give you a piece of paper and I take off and you find out it's no good. So yes, it's possible, but this is the process you'd have to follow.
The risk is crazy.
Wait, and only once you're properly registered, that's when you would pay.
You don't want to do it.
Because I mean, I wouldn't give money just on a promise, but yeah.
But if you're taking a mortgage, you have to go to the lawyer. Always, 100%.
Yes. Because the transfer of money also, because the bank sends the lawyer the mortgage, and then now the lawyer becomes responsible for what happens to it. So
right. No bank will risk, right? They will work only with the lawyer.
The alternative would be to send it directly to the client, or directly to, I suppose, the seller.
Will they do that?
No.
Never. Okay, one of the most important questions for me as well, it's life. And most of my clients are couples. What happens if, for example, I pass away? What happens to the other party? What happens to the house?
Okay, so most married couples, let's say 99% of them, are registered on title as joint tenants.
Okay.
So the word tenant is just old English, you can disregard, but what's important is joint. And by the way, this is also how joint account in a bank works. So that if one of the owners, the joint owners, passes away, their share, so to say, directly falls to the one who survives, so that there is no inheritance and there is no probate. So for example, you can't even put it into your will, which becomes null and void because that surpasses inheritance. So, and it's also very convenient. For the convenience, I think, is a big one, because you just become a full owner without unnecessary procedures, such as court procedures, probate, and whatnot.
It's only about married couple or common law couples as well, or just...
You can be two strangers.
But you have to be joint tenants.
As long as they're joint tenants, yes.
Okay.
Yes.
Okay, but if you are not joint tenants, what is other variant of this scenario?
So the second option is tenants in common. Now here you actually specify your portions. You can do 50-50, you can do 30-70, you can even do 1 and 99. Now, what's important though, if you pass away, your share does not directly fall to the survivor as it would under joint tenancy. It goes instead into your inheritance. Now, I think the easiest illustration is if you buy an investment property, you buy a condo with your friend.
Okay.
It's strictly just an investment.
Great.
Now, if something happens to you, the last thing you want is for your share to fall to them. So what happens is, and it's a dark topic, I suppose, but your friend only keeps holding their share.
Okay.
And then the other half or third or whatever the arrangement is, goes into your inheritance and is inherited by your family.
Okay.
Yeah?
So in this case, it's very important to have a will, right?
Yes.
Are you doing wills?
Yes, so yes, we do wills as well, yes.
Okay, what else is...
So I would say we do everything to do with property.
Okay.
So that real estate, which is most of the work.
Okay.
Then you have wills where you settle, you make your wishes as to how your estate is to be settled.
Actually, it's very important here in Canada. You don't have to neglect it. You have to do a will, right?
I would suggest yes.
Okay, what else?
Well, we do. Okay, there is maybe some more obscure work, but we also do notarizations. That's, you know.
Well, we very often need to notarize the documents and work with them as well, especially when we are preparing the docs for the immigration.
Yes, very well.
Okay, are you doing family law?
No, I do not.
No, everything just
Although
real estate.
Although I did start out in family law.
Interesting.
But you really have to love it. But it's a good. There's oftentimes an intersection between family law and real estate law, in a sense with dower.
Okay,
it's the clearest
exactly.
example,
Yeah.
right? So yes.
What is dower, by the way? We are mentioning it, but people might not know that.
So yes, in Canada, the Dower Act gives the spouse who is not on title the right of life estate, so that if the owning spouse passes away, the non-owning spouse has the right to stay there for the duration of their life. But more importantly, if you are on title by yourself and you're married,
yeah,
your spouse has to consent to the disposition of the homestead. So, but there is certain exceptions. So, for example, if you never lived there, and so it was not a homestead, so it was not a family home.
It was just the investment.
You don't need the consent of the spouse.
Okay. Okay. If a person has a house and has a mortgage and he wants to add somebody to the title, the bank still has to agree?
Yes. Just like if you are removing someone. Because I get sometimes, it doesn't happen too often, but I get asked, okay, so the two of us wouldn't qualify, so only one of the spouses qualifies. Can we just close the transaction, then add the spouse? The bank didn't want it in the first place. So you can. I wouldn't suggest it anyways.
But it like you cannot just go to the title office and say, add my wife over here. It will not work.
Technically, yes.
But
That's not.
title office will say it's going to be a problem with the bank, right? Or not?
No, the titles doesn't check the whether or not it's correct. You know what I mean? In a sense that because they have no obligation to the bank. But
so how can we find you?
you can find us online at www.danubelaw.ca. That's DANUBE law.ca. The phone number is 403-714-9110. We are fairly conveniently located right by Chinook Mall, so it's very easy to get to the office.
Hey, Andrej, thank you so much for coming. We've received lots of useful information today. And this is it for today. Comment, ask questions, subscribe, and see you next time. Bye-bye.
Thank you.